the ones who are responsible for telling family members that their loved one has died, their child, their parent, their friend. This is a public health epidemic. How many preventable deaths does it take to make a measure important? This is important in protecting the health of our community. On behalf of Minnesota's physicians, I urge you to support this smart, common sense measure. Thank you.
Thank you for your testimony. And I'll invite Thea Williams up to the table. Dick Davis, please state your name and title as you begin your testimony.
Madam Chair and committee members, I'm Richard Davis, here on behalf of Giffords Gun Owners for Safety in support of Senate File 1116, which would require all firearm transfers in Minnesota to be subject to a background check. Background checks are the most important tool we currently have to enforce the laws already in the books. We have procedures in place to prohibit access to guns by people who are at higher risk of committing violence, including those convicted of felonies and domestic abuse, but they only apply when guns are purchased through federal firearms licensed dealers. Those same individuals can buy a gun through a private sale with no questions asked. That's the current state of our law right now, and it's unacceptable. Background checks are extremely popular with Minnesotans, including gun owners like me. They're just common sense. You'll likely hear people testify today that background checks won't stop criminals from getting guns and will only burden law-abiding gun owners, or that transfers from unlicensed sellers are usually the people they know, so we don't need background checks on private sales. Not only are these people wrong on the facts, they represent the most extreme views on guns. Most people do indeed want their state lawmakers to pass this basic common sense law to keep guns out of the hands of people who are not allowed to have them. As a Minnesota gun owner, I strongly urge you to pass Senate File 1116 out of committee. It does not infringe on my rights and is a critical step towards gun violence prevention. Thank you.
Thank you for your testimony. Rolf Olson, you can come forward. And Ms. Thea Williams, if you could state your full name and title as you begin your testimony.
Madam Chair, member, and members of the committee. My name is Thea Williams, and I am a community outreach and training supervisor for the Next Step training, for the Next Steps program. Located at Hennepin Healthcare, North Memorial, and Abbott Northwest, Children's, Minnesota. The Next Step program is a hospital-based program that offers trauma response and recovery services to support survivors of gun violence, many of whom are in communities of color. Since 2016, we have served over 1,000 participants. We are available 24 hours a day for survivors, and when families arrive to the hospital in deep grief, shock, anger, and confusion from the senseless death of their loved ones due to gun violence, support from our program comes in whatever form they may need. Being a non-judgmental listener, we have sat in hospital rooms in the middle of the night with patients who are alone and scared. They can't sleep while they replay in their minds what happened to them. We offer group meetings for survivors to strengthen bonds between individuals, to humanize each other, and to see each other in a different light. We connect survivors to housing or jobs when their own may have been lost, or they can't go back to the community where they were injured. And sometimes, the most difficult of all, we help with funeral expenses for families who can't afford them. We have bought coffins for 10 children killed by guns. The Next Step program exists to interrupt the cycle of violence. Hurt people tend to hurt people, and violence leads to violence, but we can interrupt violence by helping to heal families harmed by guns. There is only so much we can do. We need you, our elected officials. You use your position to be violence disruptors with us. We need your help to limit access to guns for people who are not thinking rationally or who are ineligible to have them. No proposal fixes everything. There is much to do to fully stop this crisis, but these proposals today will save lives. This will protect more families and excuse me, I'm sorry.
And Ms.
More-
Williams, if you could wrap up your testimony.
Okay. So I just want to say thank you for the opportunity to speak. And we just don't want to buy any more coffins for children. Thank you.
Thank you, Ms. Williams. Pastor Olson, if you could state your full name and title as you begin your testimony.
Madam Chair, members of the committee, my name is Rolf Olson, and I'm a volunteer with Protect Minnesota. I'm a husband, I'm a grandfather, I'm a Lutheran pastor, I'm the father of a murdered daughter. In October 2007, our daughter Catherine went to a house in Savage to answer a Craigslist ad for a babysitter. What she encountered was not a woman needing childcare. She encountered a 19-year-old man with his father's pistol. It was over in 5 minutes. Catherine arrived with a backpack full of children's toys and books. She did part-time work as a nanny to help finance her path toward a graduate degree in Spanish. She loved kids, they loved her. This trip to Savage was nothing new, except it was her last. Catherine was brilliant, creative, adventurous, curious. Her dream was to put together her love of Spanish and theater for a career. But that dream ended with a bullet in her back. As a gun owner and outdoorsman myself, I'm not opposed to guns, but I know how deadly they are. And I know that what we are doing now is producing unacceptable results. I know the argument of the gun lobby that claims that any legislation will only punish law-abiding citizens. They claim that the inconvenience of a background check is unconstitutional and will have little impact. Well, try telling that to families of loved ones lost to gun violence. Consider how they were inconvenienced. Consider how my daughter was permanently inconvenienced by being put in a grave. I don't understand the morality of someone who pits the occasional inconvenience of a background check against the permanent consequence of a firearm that gets into the wrong hands. Well, the facts are clear. States with the strictest gun laws have the lowest rates of gun violence. Background checks are simply part of a comprehensive plan for public safety. There's nothing in Senate File 1116 that hinders the ownership and safe use of a firearm. It's a goal that every true sportsman supports.
Please wrap up your testimony, Pastor Olson.
Thank you for using your wisdom to help prevent further carnage in our state.
Thank you, and I just want to also say I'm so sorry for your loss. Next, we'll hear from Ramya Swamy. Please correct me on the pronunciation of your name. You're joining us virtually. You can unmute, state your full name and title as you begin your testimony.
Thank you, Madam Chair and members of the committee. My name is Ramya Swamy, and I'm the State Policy Manager for Brady, an organization that unites gun owners and non-gun owners alike to take action against gun violence. Today, I'm here to speak in support of SF 1116. Background checks alone won't end gun violence, but it is impossible for any gun law to function without the foundation of a background check. A firearm is a firearm, whether it comes from a federally licensed firearms dealer or a private party, yet current Minnesotan law treats firearms sold by FFLs different than those sold by private parties. This bill will change that. The Second Amendment is no barrier to the proposed universal background check bill because the licensing requirement at the heart of the bill uses the sort of objective criteria that the Supreme Court endorsed in Bruin. In Bruin, the Supreme Court invalidated a New York law that required individuals seeking an unrestricted concealed carry permit to show proper cause. In part, the court invalidated the law on the basis that states cannot issue concealed carry licenses based on subjective criteria. In contrast, the court suggested that objective criteria are permissible. Given that the proposed universal background check bill here requires individuals seeking to obtain any firearm, whether from a private seller or an FFL, to have a transferee permit, and Minnesota grants those permits on an objective shall issue basis, the proposed bill accords with the Bruin standard. Indeed, none of the post-Bruin challenges have overturned or challenged the constitutionality of background checks, and for good reason. The Bruin Court said that gun laws that accord with the Second Amendment's text and historical understanding would be constitutional. Public safety concerns and dangerousness have always been the justification for firearms laws, whether in the 1700s or today. Background checks like those proposed here follow in this tradition, and for the reasons stated above, I urge you to pass this bill. Thank you.
Thank you, Ms. Swamy. I'll invite our next two testifiers up to the table, Brian Ghosh and Carl Kaufman. Brian Ghosh, when you're ready, please state your full name and title as you begin your testimony.
Good morning, Madam Chair, members of the Senate Judiciary Committee. My name is Brian Gosh. I'm a lawyer and registered lobbyist with the National Rifle Association, opposing Senate File 1116. This sets up new ways law enforcement can deny a transferee permit. It essentially kind of incorporates a red flag standard into that process without sufficient due process. And that denial is good for 6 months. It could be denied again and again and again in perpetuity. It makes it difficult to loan a firearm to many types of relatives. So the bill excludes cousins, aunts, uncles, nieces, and nephews from those loans. Minnesota's got a strong tradition of hunting, and this bill would set up an owner's process for loaning firearms for that purpose. House file, or Senate file 1116 also adds a requirement for recording serial numbers and firearm identification information upon each transfer. It sort of then indirectly sets up a form of government firearm registration. Additionally, it sets up unreasonable requirements for retention of paperwork, 20 years under this provision, and unreasonable criminal penalties for violations. In this region, Minnesota is unique that it requires a permit to purchase. The neighboring states don't require that. And then in this case, not only are you saying you should have a permit to purchase, which the neighboring states don't have, you're saying the law enforcement can deny an application up to 30 days. Take 30 days to get a permit to purchase, compared to the current law, which is 7 days. Now imagine an abused partner going in to purchase a pistol, finding out that they can't buy a pistol for self-defense purposes when they need it right now, that night perhaps, because they have to have a permit to purchase. Or in this case, have to wait up to 30 days before they can get that permit to purchase and then purchase that pistol. So for these reasons and others, we would oppose this Senate file.
Thank you for your testimony. I'll invite Ben Dorr up to the table in your spot, and Carl Kaufman, if you can begin, state your full name and title.
Thank you. Madam Chair and members, my name is Carl Kaufman. I'm here on behalf of the NRA. I've been a lifelong member of the NRA, a husband, a father, a grandfather, a very active hunter and shooter in outstate Minnesota. I live in Spicer, Minnesota. I'm here today to state my opposition to SF 1116 with regards to transfers and background checks. My opposition is mostly that this is an infringement upon the Second Amendment. Second Amendment is paramount to our Constitution, as you all know. This would place a lot of gun owners in a position to register their guns via the background check. And this is an infringement upon our Constitution. There are 41 gun laws in Minnesota today. There are only 10 states in the United States that have more gun laws than Minnesota right now. This will make hardworking, honest Minnesotans, tax-paying, family, hunting, shooting, firearm collecting hobbyists, criminals, with registering a lot of these weapons. The sale of firearms is substantiated by 4473, the federal form. I don't know if you've all seen the federal form, but it is a substantial questionnaire on ownership. I would encourage you all to review this substantial document. I filled it out a few times in my career. What we need to do, we need to enforce the laws that we have. Enforcement is paramount to any of the judicial system.
Mr. Kaufman, please wrap up your testimony.
Can I finish my sentence?
Yes.
Thank you. We need to prosecute and sentence accordingly. We cannot plea bargain things out. Thank you very much for the opportunity to speak here today.
Thank you. James Anderson, you may come forward. And Ben Dorr, if you could state your full name and title as you begin your testimony.
Of course. Madam Chairwoman, members of the committee, my name is Ben Dorr. I am the Executive Director for Minnesota Gun Rights. Don't have much time, so I'll just go quick so I can't begin to tell you how opposed to this bill the members of Minnesota Gun Rights are. I suppose I could list out a bunch of statistics and tell you how this state is safer than that state because of this or that law. I could explain how universal background checks haven't saved a single life or lessened crime in any state they've been passed in. I could talk about how the Parkland, Florida shooter, the Sutherland Springs church shooter, the Las Vegas shooter, Orlando nightclub shooter, Charleston, South Carolina church shooter, the Chattanooga recruitment station shooter, the Fort Hood shooter, the second Fort Hood shooter, the San Bernardino shooter, the Aurora, Colorado shooter, Newtown, Connecticut, and Gabby Gifford's shooter, and on it goes, all passed background checks or completely circumvented the background check system before using a firearm to go on a killing spree. Or I could explain how this bill is an absolute slap in the face of law-abiding gun owners and an unforgivable undermining of our constitutional right to keep and bear arms. But I won't, because these hearings and this bill is an absolute sham. The chairman and the DFL have made it very clear that they want to strip us of our foundational rights, regardless of any opposing testimony. So all anyone can conclude from this is that this whole committee hearing is a dog and pony show put on for the anti-gun left. So I'll just leave it with this. The members and supporters of Minnesota gun rights are extremely unforgiving, and we have very long memories. Any legislator, especially the ones in weak districts, will face a full political fury of mobilized gun owners in their districts at election time if they support this bill or any similar legislation in any way. Minnesota gun rights will make sure of that, as we have for the last decade.
Madam Chair.
Senator Pappas.
Madam Chair, in all due respect, Mr. Dorr, your comments are totally inappropriate here.
Mr. Dorr, I'll ask you to vacate the table. It seems you've ended your testimony. And Reverend Tim Christopher, you may come forward. James Anderson, as you begin, please state your full name and title for the record.
My name is James Anderson. I'm from Pennock, Minnesota. I'm representing myself and many Americans who live in Minnesota. I'd just like to share some details. Recently, there was a Hennepin County drug bust. 6 people were charged. 3 of those really stuck out to me. They all had lots of drugs. A couple had money counters. Business was really good. And all had firearms. But the other point was all 3 had previous convictions for crimes that would not allow them to possess firearms, yet they all had firearms. So I'd like to believe that by bringing out these proposals such as SF 1116, you're going to help stop criminals and gun violence, crimes like this, but this will not do it. Those criminals, by their very nature, would not fill out a transfer form, would not apply for the permit. So we can't stop that crime. We have to stop behavior, and that's got to be done through enforcement. As was mentioned, we have over 40 laws on the books already. We need enforcement of those laws to put criminals behind bars for longer periods of time, and crime goes down. Washington, D.C.'s chief of police said the very same thing in the last couple of weeks. We need to put criminals in jail. Now, the other side of this proposal is that it does cause some problems. We talked about owners reporting and paperwork burdens on law-abiding citizens. There's more paperwork and work for the police in doing their work, and they're already shorthanded. They could be out stopping crime. Given that there's more work being done, I know this is free now, but when there's more work being done, the potential is there for fees in the future. Also, as was mentioned, this creates a registry of sorts for gun owners, which, as history has shown, leads to confiscation. So stopping crime is a very laudable goal, and we appreciate your efforts to try to do that. Again, it's behavior. We have to change. This proposal does not work toward that goal. We hope that you would not pass this SF 1116 from the committee and no longer put it into the process for lawmaking. Thank you for your time.
Thank you for your testimony. As you vacate the table, I'll invite forward Rob Dorr. And Reverend Christopher, as you begin, please state your full name and title for the record.
Well, thank you, Madam Chair. My name is Reverend Tim Christopher out of Berean Missionary Baptist Church. First thing, before you hit the clock on there real quick, I just got a question I need to be cleared up real quick. And that question would be on the gang involvement. Would that affect us reverends who work with gang members? I think that's something that should be cleared up right away. Would I be put on a task force? Would I be put on a list? Because I work with gang members.
Reverend Christopher, if Senator Latz would like to respond, I'll.
I think that's very important, though, for what I do, right? Okay.
Madam Chair and Reverend Christopher, there is a criminal gang investigative data system under Minnesota statute section 299C.091. I don't have that statute in front of me, but I don't think it covers people who work with members of gangs trying to help prevent violence. So
Okay.
my guess is you're pretty safe there.
Thank you very much. I thank you for
Reverend
clearing that up for me. Committee, I thank you for giving me this opportunity to sit in front of you, to give you an understanding of what goes on in places that you do not visit and you do not go. What I'm saying is this here. Yesterday, a young black man, football player from Minneapolis High School, was shot in the leg while he was walking home. I say that to say this here. These bills that you're putting out here is not going to do anything for the black community. We know that. They've said here, everyone who's testified here has said over and over and over again that these bills are not going to stop everything, right? That's what we're saying. And the places that they're not going to definitely stop anything is in the black community where we are affected big time. They're not going to do anything. So why not go after the criminals? Why not go after the people who have these guns, who are selling these guns? Let's find out where these guns are coming from. Why don't we do prevention before these kids get these here firearms? Why are we not doing that? Why are the policies that's in the black community that the Democrats are putting out there right now? Why can't we work on those policies? Why can't they pull us reverends in and sit down and talk about the things that are going on in the community to help some of these single moms who don't, and these kids that don't have fathers around, that we can do something different other than put paper down and expect paper to stop these crimes, to stop things that's going on right now. All these stores that are closing down in the black community, where are those people going to go? They're going to go to the suburbs, and all the crime and everything is going to start out there also. What I'm saying is this here. We need to start thinking about the things that we're doing. These bills, these gun bills that you guys are putting out here, not going to do anything to stop what's going on in my community, where things are going down, where kids are getting shot, right? We know that, right? Madam Chair, we know that. You and I know that. So what I'm asking is sit down with us, come into the community, and understand what we're
wrap up
doing
your testimony, Reverend Christopher.
and why these bills won't help. Thank you very much.
Mr. Dorr, please state your full name and title for the record as you begin your testimony.
Madam Chair, members of the committee, Senator Latz, I'm Rob Dorr. I am the Vice President of the Minnesota Gun Owners Caucus. And wanted to we've heard a lot about sales. This bill puts background checks on all gun sales. I wanted to give a little bit more context. The bill is actually about transfers. If I was to loan Senator Eichhorn my 300 Blackout, which is a lovely deer hunting rifle, but it has a detachable magazine, so it classifies as one of the bills that would be regulated under this. I couldn't simply loan that to Senator Eichhorn to go hunting for the weekend. He would have to go to get a permit to purchase, wait up to 30 days, and then I could engage in that transfer after I take his picture of his permit to purchase, of his driver's license, and then we both hold that receipt for 10 years. Once Senator Eichhorn's done hunting, he can't just hand me my own rifle back. Now I have to go and get a permit to purchase and get the background check done, and then we both have to hold on to that transfer for 10 years. That transfer receipt has to be held by both of us for 10 years and turned over to law enforcement upon demand, or we face a gross misdemeanor, which is up to 1 year in jail. Not with a warrant, not with a subpoena, just any law enforcement officer upon demand. That is an incredible risk to people who are lawful people who are engaging in peaceable conduct. And it is not the type of things that is going to catch the people who were actually worried about getting firearms. I think the intent of this bill is we don't want a good person knowingly selling a firearm to a bad person. And I think if that is the intent of the bill, we fall well short. The bill is much more likely to catch a good, honest, lawful, peaceable gun owner in a crime than it is to stop a single illegal transfer. According to data from the Department of Justice, less than 9% of firearms acquired by criminals come from person-to-person sales, and most of those are from family members who are actually exempted under this bill. We need to take a big look at this and actually find ways to address the things that we're looking to, not cast a broad brush and catch all of these other things. Lastly, suicides are 80% of Minnesota's gun deaths. Largely greater Minnesota people who aren't prohibited from owning guns. We need to think bigger than just this bill. Thank you.
Thank you for your testimony. That concludes our testifiers. I will just ask everyone to please remain respectful. I know that folks are very passionate about this issue. I want to thank all of our testifiers for sticking to the time limits. I'll ask Senator Latz for any final words before we go into discussion.
Thank you, Madam Chair and members, and I really appreciate everyone who came to testify today, some of whom came from quite some distance to do so. I just want to make a couple of follow-up comments in response. There are, as already identified, some limited exceptions in the bill, but perhaps I ought to state what they are so the public understands them. This requirement does not apply to the following transfers: a transfer buyer to a federally licensed firearms dealer, transfer buyer to any law enforcement agency. To the extent the transferee is acting within the course and scope of employment and official duties, a transfer to a peace officer, member of the armed forces, or a federal law enforcement officer, or a security guard employed as by a protective agent licensed. A transfer between immediate family members, which means spouses, domestic partners, parents, children, siblings, grandparents, and grandchildren. And on that point, let me say, you start getting out to extended family members, not everyone knows everything about the backgrounds of everyone in their family, especially when you get out to extended family members. So you might not know if a particular cousin has a conviction for a domestic assault that prohibits them from possessing a firearm. In fact, they might have tried to keep that as quiet within the family as possible. So there's a reason why this limitation is described narrowly. A transfer to an executor, administrator, trustee, or personal representative of an estate. Transfer of an antique firearm. Transfer of a curio or relic. Temporary transfer of a firearm if the transfer is necessary to prevent imminent death or great bodily harm. The person's possession lasts only as long as immediately necessary to prevent that death or harm. Transfers buyer to an auctioneer who's conducting an auction. At a shooting range that operates in compliance with the performance standards under state statutes. A lawfully organized competition involving the use of a firearm, or participating or practicing for a performance by an organized group that uses firearms as part of the performance. While hunting or trapping, if the hunting or trapping is legal in all places where the transferee possesses the firearm and the transferee holds all license or permits required for hunting or trapping. At a lawfully organized educational instructional course. And while in the presence of the transferor. So that last exception, while in the presence of a transferor, if Mr. Dorr wanted to give Senator Eichhorn his pistol, If they remained together during that period of time, they could do that. It'd be different if Senator Eichhorn were going to take it away for the weekend and use a pistol or a SAM-saw for hunting. I respectfully submit, most people don't use pistols for hunting, at least not the information I've been given, and most people don't use semi-automatic military-style assault weapons for hunting, or if they do, they're a pretty bad shot. And then, of course, you can't engage in this transfer if you have reason to believe that the person who you're transferring it to is not lawful to possess it. Or if you believe that they use or intend to use a firearm in the commission of a crime. So a lot of exceptions there. And a lot of people who oppose this bill, in my experience, when I have conversations with them, they all thought that they wouldn't be able to do some of these things, but they are allowed to do it. It does not surprise me that the issue of a registry has come up, because that is a very common attempt to misrepresent what this bill does. It's used that way because there were versions in previous years that could have been used to create a registry. And now, because that is a term that activates opponents, it is used even when the factual basis is no longer there. There is no central repository of any gun transfers here. The transfers can occur privately, and only the two parties to the transfer need to maintain the information about the transfer. So there isn't a way for a central repository to be put together. Now, the local law enforcement agency will have a record of those to whom permits have been issued, but that's a different question. Just to clarify, it is a 10-year retention period, and by the way, that is for the record of transfer, and that is a change, as are many of the changes that are in here over the years, based on input from people who had concerns, questions across the political aisle. I've been working on this bill for probably a decade now, had many conversations with Republicans as well as Democrats, with stakeholders who are interested, gun owners, organizations, and so on. And the bill you have in front of you reflects changes made because of that input. There was a note about an abused partner trying to run out and purchase a firearm to protect that partner's self that day. The fact is, most abused partners at risk are women. And the data shows that in the vast majority of cases, when the women possess firearms, the firearm that they possess when it's in a domestic partner abuse situation ends up getting used by the male perpetrator to harm the woman. That's the evidence. There was a long list of firearms massacres that were given to us, and the fact is, although they make the headlines, that's not when most gun deaths in the United States occur. Every day in the United States, the equivalent of these mass shootings occurs in ones and twos on the streets and in the homes around our country. That's where, if we really want to make a dent in preventing firearm death, we need to be focusing our attention. So the facts are, members, that the public understands this. There is very broad public support, 67, 80, 90%, depending on where you are, support background checks. Because they don't want people who are unlawful to possess firearms either. And that's in rural Minnesota, that's in metro Minnesota, that's Democrats and Republicans, that's gun owners as well. A majority of all those categories, a very strong majority, support a background check bill. So members, I welcome your questions, comments, concerns. I'm happy to answer them or address them as I can, and I will ask for your support. Thank you, Madam Chair.
Senator Seeberger.
Thank you, Madam Chair. Senator Latz, thank you for all your hard work on this bill. And thank you for engaging in conversations with me about this bill.
I think we all come from the same place of wanting to keep guns out of the hands of folks who shouldn't have them. And I think it is important that we try to walk that line. And this is hard work. This is hard work to understand the needs to prevent more gun violence, which are legitimate needs, and also the rights to possess a firearm if you're not otherwise not qualified to do so. This is a tough line to walk, and I appreciate all the work that you've done and all the conversations you've had and all the listening you've done on this bill. I also appreciate the folks who have reached out to me. Since last night at 6 p.m., I'm looking at my inbox right now, I have 536 new emails. So thank you for all your contact, both pro and against this bill. Thank you for reaching out. I've spent probably more time on this bill than any bill that I'm actually the author of, because my constituents feel different ways about this bill. And I've done a lot of listening, and I've done a lot of reading. I have read through this bill forward and back so many times to understand the process and what it really does, to understand what it's getting at and what the obligations are going to be on lawful gun owners who want to transfer a pistol or a semi-automatic military-style assault weapon to someone else, and what the person who wants to receive it, what their obligations are as well. One concern I do have is with regard to the record-keeping requirement, and Senator Latz discussed that a little bit. As I understand it, in a private party transaction, outside of the purview of going to a fleet farm or doing it at a gun show, it's two private parties in this transaction. They are obligated to make a record of this transfer and keep that record for 10 years. It was 20 years. With this A3 amendment, it's reduced to 10 years, and I've had many conversations on that. I have important papers too. We have a lockbox and a safe at my house. I've uploaded things. We have a safe deposit box. So there's important things that, and I get it, there's important papers and records you have to keep. But where I got a little bit tripped up is that if law enforcement asks you to produce that record and you don't have it anymore, this law makes that a gross misdemeanor. And that feels a little onerous to me. I feel like if you are in good faith doing everything you need to do, getting your background checked, making the record, keeping the record, and for some reason something happens where law enforcement comes in and demands this record, which it is compulsory that you produce it, and you can't because you lost it, or the dog peed on it, or something happened, your house burned down, or your hard drive failed, or whatever it was, now you're guilty of a gross misdemeanor, and that just feels a little unfair to me. So I'd like to introduce the A6 amendment.
Senator Seeberger introduces the A6 amendment. While that's being passed out, would you like to explain, Senator Seeberger?
Thank you. The A6 amendment would reduce this from a gross misdemeanor to a misdemeanor. I feel like there probably should be some teeth to make sure that records are retained, especially important records such as these. But I think holding people to a standard of a gross misdemeanor when, maybe in year 9.75, your hard drive crashes or your house burns down or you can't find the key to your safe. I've had that happen to me too. I feel like this is a more equitable result. It reduces it from a gross misdemeanor to a misdemeanor.
Senator Latz?
Madam Chair, first of all, I appreciate Senator Seeberger's work here, and she certainly does her homework. Evident from my conversations with Senator Seeberger on this bill. She knew everything in and out as we talked about it, and I respect that and appreciate that. I do want to clarify something that was stated earlier by one testifier, which is a law enforcement officer can't just randomly walk up to you and ask for proof of any transfers. It has to be as part of a criminal investigation. And that's in the language that's here, just for the record to clarify that. My concern about this is that a misdemeanor may not be enough teeth on this as an encouragement for someone to keep the record. But I'm going to respect the intent here. Misdemeanor crime is punishable up to 90 days in jail. So at this time, I'm going to accept this proposed amendment as a friendly amendment and encourage the committee to support it.
Thank you, Senator Latz. Senator Seeberger moves the A6 amendment. All those in favor say aye. Aye. Opposed? Okay, the amendment is adopted. And to the bill as amended. Senator Limmer.
Thank you, Madam Chair. Since we're on this subject, Senator Latz, let's suppose there was a private transfer, 8-9 years go by. What would cause a law enforcement officer to want to look at a transfer from 8-9 years in the past? People move. People may not even remember where exactly they purchased that gun. And but I'm more curious about what would cause a police officer to want to check and search for the seller of that gun after 8 or 9 years goes by, and why would we hold that individual culpable in any violation after that long of a period of time? The time factor is more my concern.
Senator Latz.
Madam Chair, Senator Limmer, once guns are out in the community, they can be transferred and they can be used. And sometimes firearms are recovered at a crime scene. If there's a way to identify the perpetrator through a fingerprint or something else, they can obviously do a search of that shooter's personal belongings, house, and so on. If they find records of transfer, then they can know who the firearm was purchased from. There may be several steps along the way there. It may be only one transfer that occurred 10 years ago. But it might be a valuable part of the investigation for the law enforcement to determine how the shooter got the firearm. So that would be the kind of scenario I would envision. Gun may sit in a drawer for 9.5 years and someone decides they're going to go use it in an unlawful way. I preferred 20 years. Law enforcement indicated to me that, the longer that the records are available, the longer they'd be able to trace the provenance of a firearm used in a crime. The 10 years was a compromise position, and hopefully that will cover what's necessary to help track down how a firearm got into the stream of commerce and how it ended up in the hands of the shooter. It's also, I think, valuable because it impresses upon the seller as well as the buyer the importance of having records, of having checked on the transferee permit, and the significance of having the records available when there is a criminal investigation. So if you say keep it for 30 days and then you can shred it, well, that doesn't tell you the paperwork is very significant. If you say keep it for 10 years because we want to be able to have the criminal investigations successful, well, that tells you it's a pretty significant document, and maybe you ought to think about keeping it like you're supposed to.
Mr. Chair.
Senator
Madam
Lemon.
Chair, Senator Latz, the federal government doesn't even require us to hold our tax records for more than 7 years. So, and in some cases, one could have more damage done to them because they did not keep their tax records for a full 7 years. If an audit was required, than what some would consider an investigation by law enforcement up to 10 years down the road. So I find the 10-year holding period quite lengthy. I find it, and if you know anything about my record keeping, I don't keep anything. Well, I probably do keep everything. My wife would say I keep everything for much longer, but we're trying to change that. I'm trying to streamline my life. A 10-year document to hold, I don't think I hold anything for 10 years. So I find that to be above and beyond a practical holding period.
Madam Chair. I have a list. I'll put you on, Senator Howe, but first we'll go to Senator Westland.
It was on this point. Sorry. Thank you, Madam Chair. Thank you, Senator Latz. I said it privately. I'll say it here. I am deeply grateful for the work that you've done on this issue. You've been a champion for trying to make our communities safer for a very long time. And I'm pleased that we're finally having a hearing on this issue and folks have an opportunity to come and express their opinions both for and against the measures. So thank you. Thank you, Senator Seeberger, also for the good work that you have done to try to make this the best bill possible. You've been thoughtful throughout this process, and I appreciate your efforts on this as well. I do want to ask a couple of questions that came up in the context of the testimony. We heard a lot from opponents about a registry, Senator Latz, and I'm not sure if you specifically addressed that, but we have opponents claiming that this is going to create some sort of a registry, which I am having a little trouble wrapping my head around because, as you noted, 60% of purchases are already covered by background checks, and this is simply trying to make sure that we're doing them on all of them. So what's your response to the statement that this is going to create some sort of a registry?
Senator Latz.
Madam Chair, Senator Westland, when I think of a registry, I think of a centralized place where records would be kept, and to deal with the issue that is presented, the government, if they wanted to, could go find out who's got any guns and go confiscate them, right? That's the argument that's always made. The government's coming after us. They're going to take all of our guns away. As you already noted, Senator Westland, the federal government already has records of all the background checks that are done through FFLs. So there's a 60% or greater number of firearms subject to this registry, if it could be said to exist already, and a lot of willing participation in that process. So I don't, but the other thing is, here, there's going to be a federal background check run through the local law enforcement agency for a particular individual, just like if you went through an FFL, except it's done here as a part of an application for a permit, a transferee permit. So we may know, who's gotten permission to purchase a firearm. We don't know where any particular firearm is. We wouldn't under any of the circumstances here. And the background information, who's actually issued the permits, they're all kept by the local law enforcement agencies, so there's not a really central repository. Now, I'm not as concerned about the government going out and trying to confiscate everyone's guns. I think that would violate the Second Amendment, and would be a pretty bad idea anyway. But I respect those who have those views. I don't see it as a result of the bill that you have before us today.
Madam Chair. follow-up.
Senator Westland.
Madam Chair, Senator Latz, I appreciate that. You've also mentioned a couple of times in your comments today that the bill that's before us today is very different from some versions in prior years and probably some versions that have been circulating this year. And it seems to me, and you can confirm this perhaps, that you have elicited input from all stakeholders, both those who are supportive of gun safety measures and those who are not. Is that accurate, that you have been attempting to incorporate input and views from all sides of this issue?
Senator Latz.
Madam Chair, Senator Westland, yes, the answer is yes, but I would take I would take a different nuance in the way you characterize it. I think all gun owners and all others are in favor of gun safety. I think we may take different approaches to how to achieve that, and I think it needs to be a multi-pronged approach. There are those who joined us at the testifier table today and on the committee who think the strongest thing that we can do is ramp up criminal penalties for gun crimes. And I've supported increasing criminal penalties for gun crimes, not necessarily as much as perhaps some members of the committee have introduced, but I introduced and got passed into law the straw purchase bill at the initiation of my own county attorney 7-8 years ago. So I think this is an important piece of it. And the fact is, if you don't have a mechanism to identify people who are trying to obtain firearms that would be illegally in possession of the firearm or would be a serious danger to themselves or other people if they got the firearm, if you don't have a way to do that, then you've got complete lawlessness. Then you've got no control over the situation whatsoever. If I were a gun owner, I wouldn't want to sell my firearm to my neighbor who I know has engaged in a violent criminal offense. Nor would I want to sell it to someone down the block that I don't know what their background is either. And they're certainly not going to tell me, and it may not be part of the neighborhood lore. Even if I've known them for 30 years, they may have something that happened to them that they didn't share with me. But that would be picked up on a background check because it's part of the legal framework. So that's the way I approach it. This is a preventive measure.
Senator Westland.
Thank you, Madam Chair. Thank you, Senator Latz, for correcting the nuance there. I would like to hope that every person who is a gun owner and a non-gun owner has as our intention to make our communities safer, and that includes gun safety issues. And again, I have remarks that I will save to the end, but I think those are my questions for now. Thank you again, Senator Latz.
Thank you. We'll go to Senator Howe and then Senator Kroon. Senator Howe.
Thank you, Madam Chair. And going back to the keeping the paperwork for 10 years is, and you said it's a compromise from 20 years. I guess I don't understand why we're keeping that paperwork for that length of time. I'm trying to figure out why and how you keep that paperwork. And I can remember I came home from a deployment. My wife had done some housekeeping, and I couldn't even get into my safe because she threw away the combination of the safe. So I think you're putting some folks in a real dangerous situation to try and keep and maintain a record of something for 10 years. I don't know how you do that. I'm more of a gun collector than a seller. I mean, I can tell that I've sold 4 guns in my life, and I can tell you exactly who I sold them to. I got no record of any of them. But I know who I sold them to. I know what gun they are, and I can find the serial number because I keep the serial numbers of my guns. But I don't have a record of that transfer. except for in my head. But I take it that's got to be a written transfer because we're going to require it to be a written transfer. And I'm going to have to do that through an FFL, I take it, which is going to cost somebody some money. Is that not correct?
Senator Latz.
Madam Chair, Senator Howe, you would not have to do a transfer through an FFL under this proposal. It can just be a direct transfer, one-on-one.
So I don't.
Senator Howe.
Just take a picture on your phone of the transferee permit. And that's like, as long as you keep that, you'd be fine.
Senator Howe.
So so I need that transferee permit or a permit to purchase in common language is what most folks use is permit to purchase, which is going to cost, if you got a permit to purchase, it's going to cost you dollars to get that permit to purchase.
Senator Latz.
Madam Chair, Senator Howe, no, that's not the case. Under this bill, there would be no charge for that application.
So
Senator Howe.
Thank you, Madam Chair. So Senator Latz, the only place you need it is when you got a permit to carry is where you got a charge.
Senator Latz.
Madam Chair, Senator Howe, that's correct.
Senator Howe.
Thank you, Madam Chair. So I want to go back to the comment about using a handgun or a military assault weapon for hunting. Senator Latz, have you ever gone fox or coyote or any hunting at all? What type of hunting have you done in the past?
Senator Latz.
Madam Chair, Senator Howe, when I was a child, I had a friend whose family hunted down in Wyndham, and I went with them duck hunting.
Senator Howe.
Thank you, Madam Chair. So you've never gone coyote hunting or fox hunting where you've got an animal that's not very large, that's running at a high speed, and you're trying to connect a little .223 round or a .556, which is coming out of what you would call an assault-style weapon in this definition. The reason you have a 20 or a 30-round magazine, because it's going to take a couple rounds to connect with them. Now, I have watched my dad, who I think was the best shooter I ever met, connect with a fox at 80 yards as it was running across a plowed field and shot it in the back of the head with a .223. I couldn't make that shot, and I am a trained sniper, but he could make that shot. So what I'm saying, when I go hunting, I do take a military style assault weapon when I'm hunting fox, coyote. In fact, some of my kids have used it to hunt deer because it's a legal weapon to hunt deer, legal caliber. And the reason they use it, because they've all been trained in the military, it's a weapon they know. They can, if it has a failure, they can take it apart, put it back together, and get it working again. It's a known weapon. They know how far it shoots. They know where it shoots. To say that that's not a weapon, not a firearm that they should be allowed to use, I think is ridiculous. And I think it's ridiculous to sit there and say that does that have different rules for the transferee?
Senator Latz.
Madam Chair, Senator Howe, this bill does not restrict anything relating to what kind of firearms you can use to go hunting. Not at all. What it does say is that what are more typical hunting weapons, as I understand them to be, are not covered by this background check bill. SAMSAW would be covered by this background check bill. Now, I might ask, where's the sport in trying to shoot a fox at 100 yards with a 30-06 instead of a machine gun? But this bill doesn't say anything about that. What it does say, if you're going to go buy a SAMSAW from someone else, you have to have a permit to purchase first.
Thank you, Senator Latz. And again, the exclusions start on 13.31. The hunting exception is on line 15.6. Senator Howe.
Madam Chair, so Senator Latz, your analogy of using a machine gun, that takes a special permit to own a machine gun. Very few people go through the requirements to get a machine gun because it's so onerous and it puts a spotlight on you. Very few people own a machine gun. In fact, I only know one person that I know of that has the permit to fire a machine gun and own and possess a machine gun. Not very many people. If they own a machine gun, usually in the state of Minnesota, they're known by the ATF, they're on a map, and if they have them shooting in Minneapolis, they should be behind bars, and I don't think this is gonna get to putting those folks behind bars. So your analogy saying that it's not much of a sport to use a machine gun or a 30-06 to shoot a fox at 100 yards, I will tell you that you can actually load a 30-06 down to take a 100-grain bullet, in fact, less than that, and it makes an excellent weapon or firearm to go shoot and hunt fox or coyote. So what I'm saying is, it just upsets me that you've gone down this road and you typically talk about us folks that like to use these firearms to go hunting, and you really don't have the background as far as what we're doing and how we use these firearms but let's go along after that. You said that I'm going after the piece where how do we determine the law enforcement officer has the determination of whether the person may be a threat to themselves or others? Where is the criteria that identifies how they come to that conclusion? Or could they possibly determine that everybody that has a firearm is a threat to themselves or others?
Senator Latz.
Madam Chair, Senator Howe, I just want to emphasize with the previous conversation that this bill does not restrict, I will say it again, this bill does not restrict what kind of firearm a person can choose to use while hunting. Not at all. All it says is that if you're going to purchase a pistol or a semi-automatic military-style assault weapon, you need to go through a background check first. That's all this bill does. Now, with regard to the question that you asked, I'm going to refer you to let me just find the proper section here with regard to the grounds for disqualification starts on page 6 of the amendment, subdivision 5. The language is whether or not a person is determined to be a danger to self or the public when in possession of firearms. And the standard is on line 7 starting on line 7.4, whether there exists a substantial likelihood that the proposed transferee is a danger to self or the public when in possession of a firearm. The guidelines for that are not specified in statute. And honestly, I don't know that it'd be very productive to list a non-exclusive itemization of those criteria in statute. We could put a list of things that might be considered or allowed to be considered, but I don't think that's necessary. There is very detailed right to review. The chief of police or the sheriff must provide the applicant with a written notification and the specific factual basis justifying the denial, including the source of the factual basis, and inform the applicant of the applicant's right to submit within 20 business days any additional documentation relating to the propriety of the denial. And then the chief of police or sheriff must reconsider the denial and within 15 business days tell them the result of that reconsideration. Then the applicant has a right, if they still disagree with the outcome, to get review of that denial under subdivision 13. So there aren't any itemized criteria, but there is ample opportunity for review, and the applicant is entitled to know specifically and in writing what the grounds are for that denial. In subdivision 13, it provides for appeal to the district court and prompt review, a hearing within 60 days, and a sealing of the record to protect the applicant's privacy, written findings of fact and conclusions of law relating to those issues, and the burden of proof being on the law enforcement agency to establish by clear and convincing evidence that there exists a substantial likelihood the applicant's a danger to himself or the public.
Senator Howe.
Madam Chair, so Senator Latz, we've increased the time, the waiting time for the allowable time for them to issue the permit to purchase from 7 days to 30 days. Is that not correct?
Senator Latz.
Madam Chair, Senator Howe, 5 days to 30 days, I believe.
So 5 days.
Senator Howe.
Thank you, Madam Chair. So is the 20 days after the denial, or is that during the 30 days? So,
Madam Chair, Senator
Senator
Howe,
Latz.
the right to appeal or seek reconsideration starts after the denial occurs. That's what triggers that running of the 20 days.
Senator Howe.
so they get the, Senator Latz, so I'm saying that they get the sheriff or the chief gets 30 days to process the transferee request, the permit to purchase. And then they, once they get the denial out, they get another 20 days after that to give them the list of why they denied it? Or is the 20 days inside of that 30 days? I'm just trying to figure out, do they have 50 days to tell them why? Or do they have 20 days to tell them why? Does the 20 days start when they receive the application, or does the 20 days start after the denial, so they actually have 50 days before they have to release why they denied the permit?
Senator Latz.
Madam Chair, Senator Howe, if you read subdivision 5, please, it indicates that the chief of police or sheriff must inform the applicant of the applicant's right to submit within 20 business days any additional documentation relating to the propriety of the denial. So the sheriff has 30 days to run the background check, gather whatever information they wish to gather. It may take them 5 days, it may take them 15. They have up to 30 days. Once they issue a denial, then the applicant who's been denied has 20 business days to submit additional documentation.
Got it.
Once that additional documentation is submitted, then the sheriff or chief has an additional up to 15 days to reconsider it and issue a decision on reconsideration.
Senator Howe.
Thank you, Madam Chair. So Senator Latz, we're looking at up to 65 days to get a permit to purchase. That's what we're looking at. You've got 30 days to respond. He's got 20 days to respond to the denial and provide additional information, and you got an additional 15 days for them to respond. To me, I'm not a great math guy, but I'm adding it up, and that's 65 days that this process could take to get a permit to purchase or a transferee permit.
Madam Chair.
Senator Latz.
Senator Howe, 20 of those days would be in the entire discretion of the applicant who's been denied, how long it takes them to get additional information asking for that reconsideration. But yes, theoretically, it could take up to 65 days, but they would have notice of their denial within the first 30 days.
Yeah, agreed.
Senator Howe.
Thank you, Madam Chair, Senator Latz. I'm just trying to get all these timelines down. So let's move on to, you got a person that may end up on a gang list that's provided by whoever, and some, if you've got the name of Johnson, you might have a lot of folks that you might have the same name as, or so if you end up with the same name as someone and you're trying to document, and you end up on that, and I haven't looked in the bill because I just got it and I've got a hand that doesn't work and I'm struggling going through the bill. But, so if I end up on that list, and I just remember when you were going through the bill, introducing it, you said down the road, you can reapply. What does that down the road, how long afterwards can they reapply if they get denied? And if they get denied, how long after if someone is not on the gang task force and they apply, they get denied, they can reapply, how long down the road, how much time can pass before they can reapply for a permit to purchase if they've gotten, these items, that the reason that they got denied the first time and they get those items fixed, how long down the road can they reapply for a permit? Can they immediately reapply, or do they have to wait a certain amount of time for reapplication?
Senator Latz.
Madam Chair, Senator Howe, they could immediately reapply if they chose to do so, but the chief or sheriff would not need to process an application unless at least 6 months have elapsed since the denial was issued or the appeal was denied, whichever occurred later. So, as a practical matter, unless there were new information that were presented to the chief or the sheriff that would justify, a reopening of the application process, it would be a 6-month timeframe before the chief or sheriff would have to consider a new application.
Senator Howe.
Thank you, Madam Chair. So what's the purpose of the 6 months?
Senator Latz.
Madam Chair, Senator Howe, so that a person who's denied can't come in every week and submit a new application and start this process over and over and over and over again based on the same information.
Senator Howe.
Mr. Chair, Madam Chair and Senator Latz, I don't know who would do that, but I'm thinking it would be a pretty simple process to deny. I would think they've already got the documentation and all this stuff. They'd have to just hit reprint, wouldn't they? I mean, I don't know.
Madam Chair,
I think
Senator Howe,
and why is 6 months the deal? How did we end up with 6 months? Is that just pulled out of the air? Is there's something that actually documents why you do 6 months instead of 30 days or 45 days?
Senator Latz.
Madam Chair, Senator Howe, every time there's an application, the chief or sheriff has to go through a specific process for the background check, and they have to provide in writing the grounds for denial. So it's not just a matter of pushing print on a computer. There is cost involved, public taxpayer cost involved every time the sheriff's office goes through the background check. They're checking the federal databases, they're checking Minnesota court systems and other databases that they believe are relevant. And depending on the circumstances and what information they gather, they might have to do some interviews or gather other information as part of the process as well if they begin to suspect that the person may be a danger to themselves or to others. So, no, they can't just push reprint. Now, how do we come up with 6 months? There were those who wanted to have these permits issued for every proposed purchase of a firearm. That was not the case here. There were those who wanted to have these permits valid for only 30 days, so you'd have a window of 30 days, and that you could only buy up to 5 guns with the permit. That was rejected. There were those who wanted to prohibit going back through the process for a whole period of a year. That was rejected. It seemed to me and to the other stakeholders involved in coming up with these conclusions, after consultation, as I've noted, with a variety of views on this point, that 6 months was a reasonable period of time, that if there were any change in circumstances, there was a reasonable possibility that might happen within 6 months. And it wouldn't require anyone waiting too long to try again.
Senator Howe, if you have another question, and then we're going to move to Senator Kroon.
Well, in that case, I guess I guess my time is up, but I will ask then, I don't believe this does anything to increase the mandatory minimums for felons in possession of a firearm. And I think that's what we should be looking at, because those are the most of the folks that are actually getting to this. You know, the way it looks at, on the average, it looks like a number of folks get reduced sentences. The mandatory minimum is 60 months in Minnesota. The maximum is 15 years. How come we're not looking at that and actually making a mandatory minimum that you're going away for a long time if you're a felon in possession of a firearm? Can you answer me why we're going after folks? The majority of folks have the firearms that we own. It's always up to the perpetrator that does this, and they usually are reoffending folks, but we're doing nothing, and most of these folks get plea bargained down. They don't even get the felon in possession of a firearm. We plea bargain that down, and they get off earlier than what even the mandatory minimum is. So we should be, in this bill, Senator Latz, looking at increasing the mandatory minimums for these. In fact, if you were convicted of a crime in the possession of a firearm, it should be increased mandatory minimums. But that's not what we're looking for here. This, to me, is looking to make those of us that have been obeying the law all along criminals. And that's where I start to have the issue. Thank you, Senator Latz.
Senator Kroon.
Thank you, Madam Chair. I'm going to go all the way back to the very beginning of your presentation. I believe you said, Senator Latz, that 60% of purchases go through the federal background check, which then, by implication, up to 40% do not. And I've heard that statistic out in the political atmosphere out there for a while now, and I'm just wondering what the source is for that statement.
Senator Latz.
Madam Chair, Senator Kroon, I can't cite you the specific source for that. I've been using it for quite a number of years. I don't remember precisely what the database was that I got it from, but that's my understanding.
Madam Chair.
Senator Kroon.
Thank you, Madam Chair.
I should hasten to add, I'm sorry, Madam Chair.
Senator
Kroon,
Latz.
because we don't know exactly how many transfers there are, there's no way to be precise about that. So we're ballparking it.
Senator Kroon.
Thank you, Madam Chair. And I think you used the word purchases, and that's why I'm asking about it in your opening statement, because I'm looking at something from factcheck.org, which isn't exactly a conservative publication, that said that figure is based on a 2-decade-old survey of less than 300 people. And the question about guns in that survey was how they acquired the firearm, not necessarily about purchasing. So, and that leads me to my next question, which is when I hear about this issue out in the community and stuff, most people think of this as kind of like closing a loophole on backgrounds, and everybody thinks about it as purchasing, but really this to me is about transfers and what we're trying to get at here. And so I just want to confirm with you, because I didn't see anything in the bill or the A3 amendment, there are no minimum thresholds on the number of firearms you have to transfer in a year or over a period of time in order for this bill to apply. Is that correct?
Senator Latz.
Madam Chair, Senator Kroon, that's correct.
Senator Kroon.
Thank you, Madam Chair. So if you have one transfer, if you do one transfer a year or even one transfer in your life, this bill is going to apply to you. And I think a lot of people out there that think about this, they're thinking of the person who's trying to do an end around about what sellers of firearms, the requirements for those sellers, and they don't think about the person that, does 1 or 2 transfers in their lifetime, or Senator Howe, who's done 4 in his lifetime. And so to me, that there should at a minimum be a minimum threshold in here for this bill to apply. So we're not ensnaring people that aren't in the regular business of buying and selling firearms into this kind of rather complicated process. That's a comment. Then my next question is, you mentioned that there is recourse in court for a denial of a permit to purchase, but is there any recourse to go to court for a revocation of a permit to purchase?
Senator Latz.
Madam Chair, Senator Kroon, with regard to your first comment about minimum numbers, I don't know how we could ever, as a practical matter, do anything about that. We'd have to rely on someone's representation that they've never bought a gun before, this is their first time. So there's no way as a practical matter to do that kind of a threshold. But in terms of your second question with the revocation, I don't know off the top of my head what the provision is in here, if there is, what the appeal process is for that. So if you give me a moment, I'll see if we have it here, or perhaps counsel knows off the top of his head where that provision is.
Mr. Backus.
Madam Chair, members, I'll have to read the bill a little more closely, but the language I'm looking at appears to limit the reconsideration to a denial of the application. I don't think it applies to a revocation. I could double check though and read it closely.
Senator Kern, do you have any final questions?
Madam Chair, I have more questions. I was waiting for Senator Latz, but I can certainly move on, and then he can jump in
Yes.
on either
Go ahead,
questions.
Senator Kern.
And that does lead me to a similar issue here, where I know in the A3 amendment, compared to the original bill that I was looking at before, it does appear that some new language is adopted regarding that hearing upon the denial of a permit to purchase. And I think that language may be borrowed from the permit to carry, or maybe something the other body did in one of their hearings, I'm not sure. But one thing it doesn't do is provide for attorney's fee provision. And my concern here is that you have, you could have a city or a sheriff who, let's say, is not very friendly to the Second Amendment and maybe makes a habit out of denying these, or denies them in situations where perhaps he shouldn't. And then the law-abiding gun owner then has to go to court and take a city or a sheriff to court and go through the whole process for a constitutional right. And then at the end of it, if they're proven right, they're out, $2,000-3,000, in attorney's fees if they want to do it right and get an attorney. And there's really nothing that they get for that. And so that's a concern of mine, but there's not really a question there. And I'm also concerned that it doesn't appear to me that there's any due process for a wrongful revocation of a permit to purchase. And then another question I had is you have in your exceptions here, after death, a personal representative or whatnot, being able to acquire a firearm by operation of law after the death of somebody who owns firearms. But does that exception apply to the personal representative distributing firearms pursuant to probate or will or other means?
Senator Latz.
Madam Chair, Senator Cruin, I'd have to parse the language on that very carefully. If we need to tweak that a little bit to make sure that the smooth transfer of an executor or probate in that kind of situation, we can certainly look at language to accomplish that.
Thank you, Mr. Chair.
Senator Kroon.
And then when we get into the holding the receipt or proof of transfer for 10 years, and it being, there was some discussion about having to produce evidence of that documentation when a peace officer requests the record as part of a criminal investigation, which is lines 13.22 and 13.23. And I believe it was Senator Limmer asked you a question about,
what would be a situation where that would happen, and you described a scenario where there's a criminal investigation going on about perhaps a firearm that was used in the commission of a crime, and that would be the reason why the police officer might request that transfer record. But my question is, in that scenario that you provided, why wouldn't the law enforcement official just go get a warrant?
Senator Latz.
Madam Chair, Senator Cruen, I suppose a law enforcement officer could go get a warrant if they had probable cause to believe that the individual who had possession of it had been committing a crime. Not sure what the standards would be if they're investigating a crime and they seek to search someone that is not suspected of a crime, but they're trying to trace the provenance of a particular firearm that was used in the crime. So it's a fair question. I think I'd like to get a little more information on how that would work.
Senator Cruen.
Madam Chair, and Senator Latz, you didn't make this statement, I believe it was County Attorney Choi, but it piqued my curiosity. There was mention of online gun sales as being part of this bill being a solution to that issue. And I'm just wondering if you or if County Attorney Choi wants to come back up, or if he's still here, if you could identify any websites out there where you can legally buy a gun without a background check and have that gun show up at your door.
Senator Latz.
Madam Chair, I don't know that that is necessarily the case, but there are a lot of transactions where the buyer and the seller are connected through online sites, and then they could decide to meet at some mutually agreed location and conduct the transfer outside of the FFL system. So I think that's part of what we're dealing with here.
Madam Chair, thank you, and thank you, Senator Latz. I just want to clear up any confusion out there, because when the public hears statements like that, they think that there are some websites out there where I can just go on, like an Amazon type website, order a gun, not have to provide any evidence of a background check, and the gun shows up at my door. And to my knowledge, that's not legal already under existing law. And so I think we need to be very careful with our words and our testimony, especially from public officials who maybe try to make that implication out there. So that's my comment on that. And then finally, one more thing, Madam Chair, I appreciate this, the time on this. Senator Howe was asking, there was some exchanges about types of weapons that would not fall under this, common types of hunting weapons. And hunting is not my area of expertise either, Senator Latz, but I do understand that, and I've learned a lot about this, that the traditional deer hunting rifle is not the only type of weapon that is used for hunting in the state. And also that there's very large swaths of Minnesota where the only weapon you can use for hunting is a handgun, a pistol or a shotgun. And so I just wanted to clear that up, and I thank you for your time.
Thank you. Senator Latz, final comments. Senator Limmer.
Madam Chair, thank you. I want to give proper respect to Senator Latz to make the final statement, but I did want to make a statement on my own. This discussion raises lots of questions, and the discussion brings up, and rightfully so, the amount of gunfire that we're beginning to experience in the metropolitan area, especially in the urban core. Many of us, I would say all of us, are concerned about that development. And it's a real problem. But using this bill to focus on basically law-abiding citizen transactions, I consider to be an overreach. I believe many of the people that are here today that are concerned about the legislation sees it as a step, an incremental step to eventually denying rights that are outlined in our Constitution. And they're concerned about that. They have a knowledge of history in other countries that have gone in that direction. And I think everyone should be rightfully concerned. This won't cause a gun confiscation in and of itself, but it's a step in a direction that it could. I believe it's focused more so in the attempt to fix a problem. It focuses a lot of regulation on a broad, law-abiding population. Wanted to clear up a few facts. When one buys any type of weapon, you have to buy it legally through a licensed firearm dealer. That's required by federal law and state law. And a background check is required. Private transactions, I believe, are a very, very small part of gun transactions in the state of Minnesota. And for the most part, they're done by law-abiding citizens. There was a fact that was made. 60% of gun purchases are registered and 40% are not registered via a private sale. That's not close to the statistics that I've ever read. So perhaps after this is concluded, someone can give me the source of that figure. Some people don't know this, but I've been told that 50% of all long guns that are sold in the country now are buying the military-style long gun. They're very popular, and they represent the modern sporting rifle in the United States. They have an appearance of a military look, but they have the shooting quality of a semi-automatic rifle, and that technology has been around for over 100 years and available for civilian purchase. So it is important to consider that. We do recognize the proliferation of gun violence. And I agree with those who believe we have enough laws on the books regarding gun use. I have heard from experts in the field that Minnesota right now is considered one of the top 10% of gun regulators in the country. We have a lot of laws on the books. Recent statistics from the Minnesota Sentencing Guidelines Commission, for the audience, they collect facts on all sorts of criminal activities, convictions. They guide the legislature at times on sentences in regards to proportion of what the sentence should be for the crime. It has been told to us by the Minnesota Sentencing Guidelines that 40% of gun convictions, those who have been convicted, the judges do not follow the sentences that the mandatory sentences that the legislature has written into law. That should be a concern for pro-gun people and anti-gun people. The legislature tries to make an underline in our state statutes when we use the word mandatory sentence. If a person uses a gun in the commission of a crime, we in the legislature, representing you, the public, have told our judges to put the guy in prison. And there are judges 40% of the time that do not do that. That would go a long way on addressing the proliferation of gun violence in this state. As I said before, I believe this bill is overbroad, And the focus really should be on the prosecution of criminals. And what many of us know, we should also pursue a vigorous expansion of mental health services in the state of Minnesota, which has been long neglected for over 40 years. I'll just conclude that, Madam Chair.
Thank you. Senator Latz, final words.
Madam Chair, I ask for the committee's support.
Wonderful. With that, Senator Latz moves that Senate File 1116 as amended be recommended to pass and re-referred to the Committee on Finance. Roll call was requested. Roll call granted. Clerk will take the roll.
Chair Umover Baton,
Yes.
Senator Latz,
Yes.
Senator Limmer,
No.
Senator Carlson,
Yes.
Senator Eichhorn,
No.
Senator Howe,
Nay.
Senator Kroon,
No.
Senator Pappas, Senator Seeberger,
Yes.
Senator Westland,
Yes.
Senator Pappas,
There she is.
Senator Pappas,
Yes.
There being 6 ayes, 4 nays, the motion passes. It's sent to Finance. On to the next bill, Senate File 2827. Senator Latz, when you're ready.
Madam Chair.
Senator Latz.
Madam Chair, Senate File 2827 increases the felony penalty for a person who owns, possesses, or operates a machine gun or any trigger activator or machine gun conversion kit from a 5-year to a 20-year felony, and the fine from $10,000 to $35,000. Members, we've all heard, some of us have seen videos of the destruction that these so-called sears can cause when they are attached to even pistols. Essentially, it's a conversion kit that can turn a single-shot pistol into the equivalent of a machine gun, rapid fire, and the destruction can be horrifying. They're on the black market. They are available to be purchased through the internet, probably on the dark web, but nevertheless. Clearly, the felony penalties that are on the books have been effective in deterring the expanded use and proliferation of these devices in our communities. So this bill would substantially increase the felony penalty for ownership, possession, or use of any of these devices. I ask for your support.
Thank you, Senator Latz. We have 3 folks signed up to testify. I'll invite the first 2 forward, Brian Ghosh and Carl Kaufman. When you're ready, please start your testimony by stating your full name and title.
Thank you, Madam Chair. Members of the Senate Judiciary Committee, my name is Brian Gosh, State Director for the National Rifle Association. Just want to point out that the increased penalty from 5 years to 20 years exceeds the current penalty for second-degree manslaughter, which is 10 years, and it puts it more on par. This 20-year penalty would be more on par with charges of sexual assault or rape. Currently, under federal law, possession of a machine gun without fitting one of the exceptions is already illegal under 18 U.S.C. Section 922. And under 18 U.S.C. Section 924A2, it puts that penalty as imprisonment of up to 10 years. So there are already laws in the books that are pretty stiff, if you will, for violating that statute. It is legal to own some machine guns, well, those ones manufactured prior to 1968, and certain FFLs can own and operate machine guns. You could have a situation where somebody served in World War II and maybe their grandchild gets a hold of an operable machine gun. You'd be looking at imprisoning this individual for up to 20 years, even though they have not threatened anybody, not inflicted any harm, and not used it in a way that would cause harm. Just mere possession of this instrument, you would imprison somebody for up to 20 years. If somebody does use a machine gun currently in a crime, there are already laws in the books to imprison that individual for a long time. So if it's attempted murder, aggravated assault, and so forth, there are already laws in the books to penalize them for a much longer period of time than the current 5 years. Thank you, Madam Chair.
Thank you, Mr. Gosh. You may leave the table, and Ben Dorr, you may come forward. Mr. Kaufman, when you're ready, state your full name and title.
Madam Chair and members, my name is Carl Kaufman, and I'm here as a member of the NRA. I'm a lifetime member of the NRA, a concealed carry permit holder for more than 20 years. I'm here today to state my opposition to SF 2827 pertaining to machine guns. This law is covered by the federal law. So I think this is somewhat redundant to do this. Now, I understand, according to Senator Latz's comment about auto sears, I do understand that. If that is the case, then those federal laws need to be applied to any of the violations used with that type of a weapon. They are illegal, and they have been, and they will remain so, according to the Act of 1934. The penalties for your outstanding citizens of Minnesota that pay taxes, they vote, the violations for them are exorbitant compared to that of a drug charge. So I think in that respect it's unfair. On the other hand, I will say that it's questionable to lump them all together. What is the definition of a trigger activator? I did have a question on that. It makes criminals out of collectors. And if you're a collector, you know, it's gonna challenge you on how you purchase and how you look at maintaining your inventory. Ultimately, we need to enforce, we need to
Please wrap up your testimony.
and we need to sentence accordingly. Thank you very much for the opportunity today. I appreciate it. One comment?
Sure, Mr. Kaufman.
In 30 years, Mr. Latz, I have missed one big game animal, and that's all I've missed. Thank you.
Congratulations.
Thank you.
Thank you, Mr. Kaufman. Mr. Dorr, please state your full name and title for the record when you begin.
My name is Ben Dorr. I'm the Executive Director for Minnesota Gun Rights. Madam Chairwoman, members of the committee, Senate File 2827 is a laughable joke to anybody who isn't a Kool-Aid drinking leftist. This bill is the definition of a feel-good measure that will have exactly zero impact on lessening crime in your inner-city gang fights. It's because we don't live in 1990s Die Hard 2 where everybody's running around with fully automatic machine guns on snowmobiles. Virtually nobody owns them, and they're a non-factor in your DFL-controlled inner-city crime sprees. When your voters burned down Lake Street
Madam
for summer
Chair,
violence
Madam
in
Chair,
2020,
I'm going to object.
to our knowledge, there was not a single
Mr. Dorr,
gun to be used.
Madam Chair,
Senator,
I would like to say that we have had an extremely respectful conversation today by people who have reasoned disagreements about things. And you have been extended respect as well, Mr. Dorr, in spite of the fact that you have failed to show the same for the people sitting in this room.
I'm showing respect to the
You
Constitution.
provided a
Mr. Dorr,
written statement,
Senator Westland
Mr.
has the
Dorr.
floor.
You provided a written statement to this committee. It is a waste of our time to have you read that statement to us. It is insulting. It is disrespectful to people who are here trying to make decisions and take in information that's actually helpful to that process. This is not helpful to our process. It is inflammatory, among other things, and frankly, it doesn't reflect well on you or your organization. And I'm going to ask, Madam Chair, that Mr. Dorr, since he has submitted this statement to us in writing, that he not be permitted to simply read it in this committee.
Mr. Dorr, you have a minute and 20 seconds left. I would encourage you to provide some additional information to the committee. I'll give you your final minute and 20 seconds. We do have the letter in front of us, so we're all able to read that.
Great. Sure. Well, this, like I said before, thank you, Madam Chairwoman, and thank you, Senator Westland. I'm here on behalf of our membership to tell this committee and to tell those who want to take our Second Amendment freedoms away that the members of Minnesota Gun Rights are not going to sit by and watch that happen. We spend money at election time. We have vast quantities of members and supporters, patriots across the state who don't want their Second Amendment rights tread upon.
Madam Chair.
Since we're only given a minute and 20
Madam Chair.
seconds to speak total.
We can stop the clock. Madam Chair,
Senator
Mr.
Pappas.
Dorr, it's really, really grossly inappropriate to talk about and make threats, election threats. Please direct your comments to the bill in front of us.
Mr. Dorr, 30 more seconds.
Is that the chair's request that I direct my comments that way, or?
I will give you 30 more seconds. As I stated, we
Great.
have the letter in front of us. I'm giving you your full time, and
Thank
I'd
you so
ask
much.
that you provide us some additional information other than what you've included in the letter.
Which is what I was doing. Again, we don't like this legislation. Our members don't like this legislation. It's a feel-good measure designed to make people feel good while not lessening crime and not solving the problems that you claim to be here to solve. So we ask that this committee vote no on this bill today, and we will let everyone know what the results are of this vote and every subsequent vote. Thank you so much for the time.
Thank you, Mr. Dorr. Senator Latz, any comments before we go into discussion? Okay. Senator Howe.
Mr. Chair, thank you, Madam Chair. And Senator Latz, I got one question. And how many people have been convicted or even charged with this violation in Minnesota in the last 10 years?
Senator Latz.
Madam Chair, Senator Howe, I don't know. But if the approach to preventing crime is to beef up penalties and get tough on crime that way, here's your chance to do it. We know these auto-sear devices are on the streets. We know that they are proliferating. What I have not brought in to testify are police officers who have responded to crime scenes or victims have been splayed out from firearms containing these auto-sear devices. I'd ask for your support for this increase in criminal penalties.
Senator Howe.
Thank you, Madam Chair. And Senator Latz, you know, I'm not going to agree or disagree with whether they've been used on the streets. They probably have. My question is this does nothing to help us prosecute those folks, and that's what's lacking. That's my problem is we have no one that I know of in the state that has been convicted or charged in recent memory of anything under this statute. So that's my concern. Thank you.
Senator Westland.
Very briefly, Madam Chair and Senator Latz, I'm having a little mental whiplash because we literally just heard on the prior bill that we should be increasing penalties for criminal behavior. My understanding is you aren't taking away anyone's Second Amendment right. You are increasing penalties in this bill for behavior that's already illegal. Is that accurate?
Senator Latz.
Madam Chair, Senator Westland, yes.
Senator Westland. Senator Limmer.
Thank you, Madam Chair. Just a question to Senator Latz. On our books now, possession or the operation of a machine gun or a trigger activator to convert a gun to a fully automatic is a 5-year sentence, and your bill wants to move it to 20. So could you give me a justification for the 20-year? It seems like we usually don't jump that far when we're making a difference in sentencing. We do it more in an incremental way, so why are we bumping it up 400% in a sentence like this?
Senator Latz.
Madam Chair, Senator Limmer, 2 reasons. One is, given the perniciousness of what's on the streets today, 5 years was way too low. It doesn't reflect today's situation. Secondly, if we go to 20 years, I'm pretty certain, I'm looking for the verification of this, that it will become a presumptive commit if there's a conviction. And we at least need to get up past that point for these auto sears, in my judgment.
Senator Limmer.
Senator Latz, the only concern I have on this is whether or not there's judges that are willing to make that sentence a reality, knowing that many of them in their past performance aren't even following our mandatory minimum requirements for the use of a gun in a crime. Thank you, Madam Chair.
Senator Carlson.
Thank you, Madam Chair. And stop me if you see me going off track here, but I do need to make some corrections and perhaps even some observations on one of the testifiers we had. I'm not sure. Well, first of all, I do not like the threats that we have had to sit here and sit through. I have had those from the Minnesota gun rights people. There is a video that blames me for San Bernardino, Fort Hood, Chattanooga, Orlando, 9/11, and other things. And that has been on YouTube for several years, blaming me, showing my family, showing me get sworn into this office, and saying that called Jim Carlson and displaying my phone numbers. I have gotten lots of threatening calls from that video. Now then, I have to say that there's another issue that goes in the background here, and that is Mr. Doar said Minnesota gun rights, but we have a letter from the House of Representatives signed by 16 representatives, most of them Republicans, that say, and I'll just read the last of it here, don't be fooled by the fake out-of-state Minnesota gun rights. They're not working with us, and they're not working for you. This came from the Minnesota House of Representatives because Mr. Doar was centered in Iowa, not Minnesota. And I realize that he has now moved to Minnesota. But this is a truth that you need to consider when you hear all of the other things about his supporters in the background. He loves to embellish. He loves to threaten people. And this cannot be tolerated in the sentence. So thank you, Madam Chair, and I'll I'll show you with my vote.
Thank you, Senator Carlson. Do we have any final comments about the actual bill? Okay, Senator Latz.
Madam Chair, just to amplify the answer to Senator Limmer's question, the fiscal note, which is included in our materials, indicate that if this is ranked, the Sentencing Guidelines Commission is assumed it will rank it as a severity level 8, where it's a presumptive commit.
Thank you.
Madam Chair, I move that Senate File 2827 be recommended to pass and be referred to the Committee on Finance.
Senator Latz moves that Senate File 2827 be recommended to pass and referred to the Committee on Finance. All those in favor say aye. Aye. Opposed? No. Motion's adopted. Senator Latz, on to Senate File 1117.
Madam Chair, I'm going to ask the committee's indulgence for a 3-minute break.
Okay, Senator Latz. We'll take a brief recess.
Thank you, Madam Chair.